number 185, Kimmel versus the State of New York. Thank you. Good afternoon, Counsel.
Good afternoon, Your Honor. May it please the Court, my name is Mitch Banis. I represent the defendant appellants, the State of New York and the New York State Police. And with the Court's permission, I do reserve 3 minutes of my time for rebuttal.
You may have 3 minutes, sir.
Thank you, Judge. The issue presented on this appeal is whether the inclusion in the definition of civil action in Article 86 of the CPLR of the phrase civil action, the phrase judicial review, means something or not. I respectfully submit that the Appellate Division erred when it read that limitation on the definition of civil action out of the statute. I think first you need to start with the general rule, the American rule, with respect to the bearing of fees, which is that each party bears its own fees. Since Article 86 is in derogation of the common law, that needs to be strictly construed. So you start off with that basic rule, and then you go to the statute, the Equal Access to Justice Act, or Article 86. The title of that act is Attorney's Fees in Certain Actions Against the State. Not all actions, but certain actions. And the legislature didn't stop at just saying that the state...
Counsel, the state statute is modeled on the federal version, correct?
It is, yes.
Yes, okay. So under the federal version, is your interpretation, does that also hold under that version?
It does, Judge. And
why is that?
Because while the federal act, first of all, it is in certain respects similar to the state statute and vice versa. It's different in one very critical respect, and that's the respect we're talking about. And this court actually, I believe it's in the New York State Clinical Laboratories case, recognized that there are critical distinctions between the state statute and the federal statute. And in particular, what the federal statute says is that essentially the federal statute applies in any civil action other than the cases sounding in tort, including action seeking judicial review. That stands in stark distinction to the state statute, which in the very definition of civil action limits the statute to those actions seeking judicial review. So in other words, the federal statute is much broader than the state statute because the state statute limits the applicability of the act to actions seeking judicial review. And I submit that the term judicial review is clear and unambiguous.
Why didn't it just say judicial review of agency actions?
Because it's implicit in the term judicial review. Judicial review is a term of art that's been around for hundreds of years. There's a cardinal rule of statutory construction is when terms of art are used in a statute, the entire history of what resulted in the term of art is basically subsumed or embodied within the statute. And here we have the use of a term that for hundreds of years has meant that very thing, which is the review by the judiciary of acts of either the executive or the legislative branch.
Why couldn't the definition be read the same way that the statute is written, which doesn't say judicial proceeding, it says civil action?
Because then,
8601 just says any civil action brought against the state.
That's right, Judge, but it goes on to define what that civil action is. And what the definition says is that it's any action seeking judicial review. So whenever you see the words civil action in the statute, you need to incorporate the definition. And by definition, what the statute incorporates is that the action must necessarily, if the statute is to apply, embody some sort of judicial review. And this action does not. Essentially, by reading out or ignoring the definition of civil action, or the judicial review component in the definition of civil action, the appellate division read that requirement completely out of the statute. If all the quote-unquote judicial review means is an action brought in the courts, you don't need the definition. Every civil action is brought in the courts. And according to the appellate division...
Doesn't the statute say any civil action or proceeding brought to seek judicial review?
It does, yes. But regardless of whether it's a judicial action or whether it's a proceeding, it needs to have that judicial review component in order for the statute to apply.
So you're saying you can read it all together as one, or as the chief judge indicates, it could be read as two separate components, right?
I'm not sure I'm following the
So it's
question.
you're reading it as any civil action or proceeding subject to judicial review, right? And I think what the chief judge is asking, why don't you read it any civil action or any proceeding subject to judicial review? Is it because the word any or a is not there?
It's because I think either way, judicial review modifies both.
Well, that's the question.
Yes, it does.
That's the issue.
Yeah,
Well, would it, and I'm going to follow up on Judge Stein's question, would it modify civil action if there was an a or any before proceeding?
I think it would, yes. To read it otherwise would be to ignore the stated intent of the statute, both in the governor's memorandum of approval, and also extensive discussion and reference in the legislative history of the object of the statute, and which is something I think is significant as well.
We look to legislative history regardless of whether the language is ambiguous?
Pardon me?
Do we look to legislative history regardless of whether we think the language is ambiguous?
Oh, I think you can. Yeah, there's no rule of construction that prevents you from reviewing the legislative history, even if it's clear and unambiguous. And I think the court, in prior cases, has recognized what the object of Article 86 is. On two occasions, in the New York State Clinical Laboratory case and Whitlinger, this court had the opportunity to talk about what the statute was intended to affect. And in the New York State Clinical Laboratory case, the court recognized that the intent of the statute is to help individuals who may not have the resources to sustain long legal battles against an agency that's acting without justification. Classic reference to administrative proceedings and judicial oversight and review.
Can we go back to the language? I just want to go back to the language of the definition. The definition takes out matters commenced in the Court of Claims.
Correct.
And could you bring an action or proceeding in the Court of Claims for judicial review of anything, of a state action or state agency action?
Not as the primary object of relief, but the Court of Claims also has the ability to award declaratory or injunctive relief incidental to claims for monetary damages. So the purpose of including that language is to make absolutely clear that even if there's some sort of ancillary, injunctive, or declaratory relief awarded in a Court of Claims action, that does not serve as the predicate for an Article 86 award.
What about like eminent domain proceedings where the state has acquired property? Can that be brought in the Court of Claims?
I do believe it can, and I think there's some, in limited instances, there are provisions in the eminent domain procedure law which allows for an award of attorney's fees. So in that situation, you could well be back, unless one of those particular situation applies, you could be back within the ambit of the statute. And a little more about the Court of Claims exception, because I do think it is an important point to be understood here, is that we talked earlier about the federal EAJA and the fact that the state EAJA is modeled to a certain extent on that statute. And the federal EAJA, one of the similarities is that the federal EAJA excludes tort claims. When that got imported into the state statutory scheme, that became the Court of Claims exception, because that's where you bring tort claims against the state. And there is a certain amount, I think, of belt and suspenders or redundancy, including the Court of Claims exception.
But this is not a tort action, is it?
No, it's not.
Right.
No, I was just explaining in terms of how we get from the federal EAJA to the State Equal Access to Justice Act. But to the extent that there is some redundancy there, I think the court is obliged to harmonize the two different provisions of the statute rather than render one of the provisions entirely superfluous. I think there's a distinction between redundancy on the one hand and on the other hand, rendering a provision completely meaningless. And here the appellate division construction of Article 86 did render the judicial review component of the definition of civil action completely meaningless.
Are costs and fees ever recoverable under the EJA when you're seeking lost damages or compensatory damages? Are there ever any situations where you could cover it?
You mean in the abstract, or have there been any cases where that fact pattern has been
Both.
presented? Okay, I'm not aware of any fact pattern where
Well,
that...
what's your position? Are they recoverable?
No. And that's because that's not the object of the statute. This court recognized in Whitlinger and the New York State Clinical Laboratories case, the purpose of the EAJA was to help incentivize litigants who were the victims of administrative, executive, or legislative excess to pursue claims when the amount at stake, the amount in controversy, did not sufficiently provide the incentive either for a lawyer or for the litigant to pursue the claim.
What, if any,
That-
relevance does the amendment, the 2015 amendment to the state human rights law to allow for recovery of legal fees in this type of proceeding? What, if any, relevance does that have to
I don't-
our analysis?
I don't think it has any relevance at all. Number one, it expressly applies only prospectively to actions commenced on or after its effective date. And number two, it applies only to cases of gender discrimination. So notwithstanding the amendment, the state still remains the only employer in the state of New York subject to an award of counsel fees in all discrimination cases other than those cases based on gender.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, I'm Vince Bizard, and I'm here representing the plaintiff, Betty Kimmel, and her longtime lawyer, Emmeline Logan Baldwin. To put the state's argument in context, we have to go back to 8601 of the law, which provides that any civil action is covered for the prevailing of fee, for fees to a prevailing party.
Mr. Bizot, then you have the specific definition in 8602
That's correct.
of action. So how do those two
Well,
provisions?
8602 is even stronger because it says any civil action or proceeding. The difference is the judicial review issue, which is, I assume, what you're getting at. But that issue has to be looked at through this broad funnel in the statute that says any civil action, and now the state wants to take it down to a pretty rare form of civil action.
But does that sentence in 8602 make any sense if you just read it as any civil action, what?
Yes.
There's nothing, what's the rest of the sentence?
Any civil action, judicial review works there, because one of the fundamental problem with the state's police's argument is that it says that judicial review has this technical meaning as a term of art, and it doesn't. It can. It can mean agency review and administrative review and review of acts of the legislature. But this court was in the Pan Am case, extensively cited in our brief, this court held that there were two kinds of proceedings available to a person being discriminated against: administrative proceeding and then judicial review. Judicial review has to mean the statutory right provided under the executive law to bring a lawsuit. So this court used the language in that case to mean just this, a judicial forum.
But it doesn't apply to the Court of Claims.
It does not apply to the Court of Claims, and that's important for a number of reasons. First of all, it's not left to inference like the state police are trying to do. Is it, well, judicial review means, it says specifically, with specific language, that Court of Claims is not included.
But
That's the best.
Why would the legislature want to leave the Court of Claims out of it if your analysis that they intended to allow for counsel fees in civil proceedings as opposed to administrative proceedings?
Torts, elimination of torts, which this isn't.
That's the sole reason for it.
Well, it tracks well with the federal statute, which has been pointed out by the court, is supposed to be similar. Both say any civil action. Both say the federal action says, the federal statute says torts. State statute says Court of Claims. They're therefore parallel. But the importance of that explicit phrase in the statute excluding the Court of Claims is that if judicial review means what the state police says it does, it's not necessary.
Well, then why wouldn't it just say except in tort actions?
Well, because, and the state admitted this in their brief, that the purpose is, this is on page 25 of the reply, that there are two reasons for judicial review. One's enough to avoid the redundancy issue or the superfluousness issue. It eliminates from fee consideration all prior proceedings that spawn the judicial review. In other words, the purpose of judicial review is to make clear that administrative proceedings are not covered unless it's remanded, which is possible in some. But Judge Stein, you asked the question, and it's absolutely apt, and that is, why didn't they just say it? Because they're relying on this inference from judicial review, and they cite a whole bunch of cases. The only state case that refers to judicial review they cite is in a dissent from the Fourth Department.
But there's never, as far as I'm aware, there's never been a case before. All the cases that address this are proceedings to review agency action. And that's all that's talked about, as far as I can tell, in the legislative history. Doesn't that mean something?
Well, I think the Fourth Department was right, first of all, because it is clear. But the legislative history, the early legislative history relied on heavily by the state of New York, was specifically addressed to administrative agencies. No question about it. And it was put in the Administrative Procedures Act for agencies.
But I'm just talking about the history, even if we disregard all of that history, just the history of the 1989 Act. That's all they talk about.
Well, the Assembly bill, the Assembly memo, which was from the sponsor of this bill, does not, says just any civil action. But I go back to the point.
Well, but that's in the context of the whole conversation, and in the context of the conversation that they want to make sure that it's not going to cost the state an outrageous amount.
Well, they use the federal experience to calculate costs, and that clearly applies to any action. So that should not be the issue. But it's important to go back also to the fact that there is this redundancy which they can't overcome, that if it means, if judicial review so clearly means only declaratory judgment actions in Article 78, then it renders superfluous the very explicit language of the statute. And you cannot, the rules of construction are...
You mean 8601, any civil action? Is that what you're talking about? It would eliminate?
Yes, well, it would...
But what other action, could I just ask,
Yes, ma'am.
what other action besides a declaratory judgment action would be brought, other than in the Court of Claims, to review a state agency or its officials or anything like that? Is there some other type of action besides a declaratory judgment action that would be brought?
Well, the state refers to actions for an injunction, but it is a valid point when they say any civil action or proceedings, so proceedings are covered over here. And so that narrows down to this little tiny subset of civil actions, declaratory judgment actions, which are not typical. But the other point I want to make that's clear, because we've been kicking around the term agency action, it's not limited to agency action. It's also, it includes, for the first time, based on contrary to the prior history, it also involves actions of individuals, officers, officials, not just agencies. And there doesn't have to be a written record. Under Willinger, there was an issue of delay, and decided by this court, which did not deal with the issue of judicial review, he said. But it's conduct. It's the conduct of the parties. So we're already way beyond the dictionary definition of that the state cites of agency review of findings of fact and legal conclusions. It's way beyond that.
How do you address Mr. Banis's distinction between the federal EAJ and JA and the state EAJA, the language there?
Well, first of all, they say the statute in this case, our statute, says it's supposed to be similar, and also says that it brings in the body of law, and there's no question about the fact that the federal statute covers any case or any civil action. And we've talked about the tort. But then it has a subset, the federal statute now, including proceedings for judicial review of agency action. Federal government didn't leave it to chance. They said agency action. Now, the state statute arrives at the same conclusion in a different way. Says any civil action, but then defines action to include judicial review of an action of the state. But then judicial action of the state includes actions not just by agencies, but by individuals, which were involved here. We had an agency involved because they disciplined her for an unprovoked assault, and then we have the acts of the agents who engaged in the discrimination, and then the higher-ups who didn't follow up on the complaints. So we have actions in conduct.
Yeah, but wouldn't that make more sense if she had brought some kind of administrative proceeding against her employer, both the state troopers and the individuals, and there was some decision based on that, and then she went to court to have that reviewed?
Well, then you're here on your arbitrary and capricious standard. She has a statutory right. People who are discriminated against have a statutory right to bring a lawsuit when they're discriminated against, and this is the most egregious possible discrimination. She has a right not to be...
What about the fact that the state statute talks about, refers to the record before the agency or official in determining whether the action in question was substantially justified? Why would it do that?
Well, for two
I mean,
reasons.
how could it be based on that unless there was an agency record or record
Well,
of the official?
Your Honor, there will be times when it would be. But we know from Willinger that conduct is involved. That was a delay case, and they looked at the reasonableness of the conduct. And this court in Willinger said, we look at the conduct. So here you could look at the conduct, her complaints, the record would include her complaints, what, if anything, they did about it. It would include the complaint or the fact that she was disciplined for an unprovoked assault. All of the things that happened to her during the 13 years she was, or 1980 to 13 years she was a trooper, could be, there's a record, but.
But it's not an agency record.
Well, if there's an agency, yes, but it doesn't have to be an agency.
But it doesn't say if there's an agency. It says in determining whether the action was substantially justified, you consider the record before the agency or official.
Well, we know that in judging the conduct under Willinger, that there was not a record in that case. There was an issue of delay. And so you don't, it doesn't have to be a neatly bound set of documents. The court says, this court said, it's conduct. Now, if I could, also on the issue of the definition of judicial review, the state in its reply cited a number of cases from other states for the proposition that when it says judicial review, that means that's limited to agencies. The difference was, and we pointed out, the difference was in every one of those statutes, the statute said judicial review of an agency action or decision. They didn't leave it to inference or chance. So all of those statutes reinforce the point that if this legislature had intended to so limit it, they would have said so. I would like to talk, Court, please, just a moment. The other point I should make is that if the legislature, if it had intended to limit it to insert administrative proceedings in this, which it did not, it's just not in there as the Fourth Department. Administrative proceedings, agency proceedings are not in there. It violates the rule of construction to infer that term when the legislature, if that's what it meant, it would have said. The legislature was simply making the distinction the state pointed out, that it's got to be a judicial action. That's why it's in there. I would say also that on the issue that we ought to take a look at the purpose. This court said in Willinger that allows plaintiffs to gain attorney's fees. The statute seeks to help those whose rights have been violated, but whose potential damage award may not have enough to induce the lawyer. That's why you also need to look at that purpose. The record shows that that Ms. Kimmel tried to find a lawyer, could not find a lawyer because there wasn't going to be enough involved, even though the treatment that she suffered was obviously so terrible, so egregious. So this statute would provide relief for those people and send a signal to lawyers that they can take these cases under these very limited circumstances. Now, to go back to the issue of what does certain mean, certain lawsuits.
Well, we don't need that now because, well, now at least in some cases, the human rights law does statutorily allows counsel fees.
Yeah, on gender.
On gender, yeah.
But all the other people who are out there making very little money and being discriminated against would have a hard time finding a lawyer just like she did.
Thank you, sir.
Oh, okay. May I make one more sentence?
You may.
Thank you. This case demonstrates more eloquently than anything could the power of the state when it decides to not settle or to really go after and grind down a needy plaintiff, and would serve as a beacon to lawyers who take on these cases, they would be paid, and it would also serve as a deterrent. Thank you very much.
Thank you, sir. Mr. Benz?
Thank you, Judge. And actually, a lot of what I would have said in rebuttal, it's obvious that the court grasped by virtue of the questioning, so I won't repeat it here. But Article 86, as Mr. Buzzard points out, Buzzard, I'm sorry, it is a funnel. And part of that funnel is the judicial review component. And Mr. Buzzard referred to the other state EAGAs and the federal EAGAs as including in close proximity to the term judicial review, agency action, official action. And our statute gets to the same place just via a different route because it's included in the definition of the state. So when you read it all together, judicial review in our statute applies to agency action and official action just as much as in the other statutes. But you've still got to have, the point is, you've still got to have some sort of agency action. And in terms of the
In this case, as Mr. Bazat points out, there was some difficulty by this claimant in finding a lawyer to represent her, and isn't that one of the purposes of the EAJA? And based on what I think I read about what she recovered, it's 20 years later, and she recovered, something a lot less than she was suing for, and if she had to pay her lawyers out of that for 20 years' worth of work, isn't that really punishing her
well, no, and it's often
instead of the state who delayed and kept this going?
I don't subscribe to that narrative. There's plenty of blame to go around on both sides in terms of why the case took so long to get resolved. But that's really immaterial, I think, to the statutory language that the court is charged with interpreting. And it's a very easy, very subjective thing to say, I had a hard time finding a lawyer, when the fact of the matter is, she did find a lawyer. She found two lawyers. She recovered $800,000 in damages. That's just not the kind of case that Article 86 of the CPLR and the Equal Access to Justice Act was intended to incentivize. The whole purpose behind the act is, again, this court has recognized in Whitlinger and in the New York State Clinical Laboratories case, was to incentivize litigants and attorneys whose monetary stakes aren't sufficient to incentivize a battle against City Hall. And when you use phrasing like against City Hall, that's classic Article 78 type language that's clearly referring to situations where you're talking about administrative or executive excess or unfairness.
Thank you, Mr. Benz.
Thank you, Judge.